We're live.
Good afternoon. This is the House Judiciary Committee, and it is the 7th of April, 2022, a little after 3 o'clock. And just down the street here in the United States Senate, they have confirmed the first African-American woman to be a justice of the Supreme Court of the United States. And we're very, very happy for Judge Ketanji Brown Jackson, and wanted to recognize her great accomplishment and her accomplishments and her continuing accomplishments as she gets ready to take the bench on the highest court of the land. Thank you very much for that round of applause, virtual round of applause. We have a number of bills on the voting list. Many of them are cross files. All of them are without amendment. There are no amendments offered for any of them. So these will be straight favorables. They match other legislation that we have passed earlier in session, but we will still go through one by one, and we will go through and talk about each and every one of them. I understand Delegate Cox was having difficulty getting onto the call. Delegate Grammer was having difficulty, but now he's here. So we will, I see Delegate Cox. I know Delegate Munoz was having some difficulty logging in. So I will slowly do our first bit of legislation here, which is Senate Bill 151. Senate Bill 151 is the cross-file for Delegate Jackson's bill that we passed. It is in, the Senate bill is in the same posture as the House bill.
Move favorable.
Motion for a favorable, is there a second?
Second.
And a second. Is there further discussion on Senate Bill 151? Seeing none, the Vice Chair,
Yes.
Shoemaker,
No.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Pardon,
Yes.
Conaway is excused. Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
My mouth is frozen. Yes.
Grammer,
No.
Howell,
Yes.
Rachel Jones, Rachel Jones, can't hear you.
Can you hear me now?
Yes. Lopez,
Yes.
McComas.
Could I ask to clarify, is this Senate Bill 151, Senator Carter's bill?
It is.
Okay, and it's the hate crimes false statement to a law enforcement officer?
Yes.
Okay, all right, just give me 1 second, sir. Okay. Just checking. Okay, I'll vote yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
It's 18, or yes, 18-2. Go now to Senate Bill 614, Senator Waldstreicher's bill. It is the cross-file, clean cross-file for Delegate Shetty's bill that has to do with changes to the controlled dangerous substances schedules and making adjustments to that.
Move favorable.
There's a
Second.
second. There's a motion and a second. Any discussion? Seeing none, Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Conaway is excused. Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
It's 20. Let's go now to Senate Bill 280. This is a cross file of Delegate Crutchfield's bill that allows people to file temporary protective orders electronically through a video conference link, at least when the commissioner's office is open. I think I got that mostly right, Delegate Crutchfield.
That is correct.
And we passed your bill in the same posture as the Senate bill is passing.
Yes.
Move favorable.
Motion for a favorable and a second. Any discussion on Senate Bill 280? Seeing none, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes. Yes.
Munoz,
Yes.
Shetty,
Yes.
Jam,
Yes.
Tolles,
Yes.
Williams.
Yes.
20. Senate Bill 649. We'll dispose of some more marriage fees, this time Frederick County, everybody. This is the cross file for one we already passed. Yes, and there are no amendments. Could I have a motion?
Move favorable.
All right, is there a second?
Second.
All right. Any discussion? All right, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Cox,
Yes. Sorry, had trouble.
Crutchfield,
Yes.
Davis,
Yes.
Fisher, Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Jam,
Yes.
Tolles,
Yes.
Williams.
Yes.
20. Senator West's bill, House Bill 36, allows for the electronic execution of wills and other trust instruments.
Move favorable.
Motion
Second.
favorable. Is there a second? There's a second. All right, great. Any questions about Senate Bill 36? Seeing none, Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
All right,
Yes.
20. The first of two bills to increase salaries for courthouse employees. This one for the circuit court clerks. This was a cross file for Delegate Williams' bill.
Move favorable.
Here a second?
Second.
All right. Any discussion? Seeing none, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
No.
okay, Bartlett,
Yes.
Cardin,
Yes.
Cox,
No.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
No. No.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
No.
Munoz,
No.
Shetty,
Yes.
Cham,
No.
Tolles,
Yes.
Williams.
Yes.
See 14 adopted. The other one, the Register of Wills.
Move favorable.
This is Senate
Second.
Bill 232, moved and seconded. For a favorable, anybody have any questions or anything? Delegate McComas,
Mr. Chair, what was the House bill? This is the Senate bill we're voting on or vice versa?
The House bill was 518.
Okay,
I suspect that the vote will probably be the same as the last bill.
well, you can never tell.
You never know.
That's right.
Very exciting here in the House Judiciary Committee.
That's right.
All right. Well, now that we've built up a sense of excitement and drama, let's take the vote on this one. The Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
No.
Bartlett,
Yes.
Carden,
Yes.
Cox.
No.
A little dramatic for that. All right, that's fine. Crutchfield,
Yes.
Davis. Davis, you are muted.
Yes.
All right. Juanita Fisher,
Mr. Chair, everyone's confusing me. What bill number are we on?
this is Senate Bill 232, which is the cross file of Delegate Williams 518, which raises the maximum salary for Register of Wills.
Oh, okay. I was wondering why the no, okay, I was confused by the no's. I'm sorry. Yes.
Okay. Delegate Grammer,
No.
just saying, Delegate McComas said that, anyway, Delegate Howell,
Yes.
Rachel Jones.
Yes.
All right. Lopez,
Yes.
Delegate McComas.
Carmack says no.
Built this up so much and then it's just the same. Delegate Munoz,
No.
Shetty,
Yes.
Jam,
No.
Bowles,
Yes.
Williams.
Yes.
All that 14-6. Same. All right. Got all excited. All right, so Senate Bill 508. I'm putting this over here. Senate Bill 508. This is Delegate Crutchfield's cross file. Delegate Crutchfield, would you mind just for a second reminding us what this bill does?
Sure, if you can bear hearing the noises around me. Yeah, so this is 508, and what it does is it provides that the gives the guidelines for guardianships, providing that the court finds by preponderance of evidence that that is in the best interest of the minor. There's no testamentary disposition has been made. Neither party is willing or able to serve as a guardianship. Each parent consents to the appointment, and no parent files for objection of the appointment. So it just sets it out and allows for those that have an interest in the child to be able to file a petition for guardianship.
Okay. Any
I thought we
questions?
were on 432.
No, we're on 508.
Oh, okay.
Where's 432? Oh, no, we're not doing 432.
Okay.
432, right, there's a Baltimore County bill that's 432 that we're waiting for amendments from the Baltimore.
Okay. Okay.
So we're on
Sorry.
508. All right, any questions?
Move favorable.
There's a second?
Second.
All right, great. Any further questions? Seeing none, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway is excused. Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
Comas,
Yes.
Munoz. Munoz,
Yes.
Shetty,
Yes.
Jam,
Yes.
Bowles,
Yes.
Williams.
Yes.
20. Okay, 694, Senate Bill 694 is again a cross file of a Delegate Crutchfield bill that has to deal with guardianship and the property of disabled persons.
Move favorable.
There's a motion for favorable. Is there a second?
Second.
All right. Any questions regarding Senate Bill 694? It's in the same posture. Seeing none, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
I'm so sorry about my mouth situation today. Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Jam,
Yes.
Bowles,
Yes.
Williams.
Yes.
All right, that's 20. Okay. Senate Bill 775. Gonna pay people a little more for their day of jury service. This is a clean cross file of the Senator of Delegate Moon's bill. How about that? Can I move-
Move favorable.
second?
Second.
All right. Any questions? Seeing none. Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Absolutely.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Bowles,
Yes.
Williams. Williams,
That's not it. Yes.
all right. 20, let the parking garages and many cities rejoice. Senate Bill 878. People will be able to park now. Only here for 4 more days, it's fine. Senate Bill 878 is affixed to the Trust Act. It's a clean cross file of Delegate Cardin's bill. Have a motion?
Move favorable.
Is there a second? All right. Anybody with questions?
I'm sorry, what's the bill number?
878. House bill was 1049, and I will start to do that a little more, and I apologize for not doing that more. Sorry for those keeping score of previous actions. Sorry about that. Any further questions? All right, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
20. Senate Bill 906 is a clean cross file of a local bill, 692, which we moved earlier. We have a letter from the Carroll County delegation, except for one person who's not going to vote on it here today.
Move favorable.
Is there a second?
Second.
All right. That's fine. Any discussion?
Quick question.
Yes.
You said, I couldn't hear everything you said. Did you say Carroll County is not going to vote on? I couldn't hear what you just said.
There is one member of the room here who is excused.
Oh, okay, that's what you said. Okay, thank you.
Yes. Well, there are two. One of them is not on the call. The other is not voting on this. Delegate McComas.
Just real quick, what was the bill, the House bill number, sir?
The House bill number was 692. 692. This bill says that the state's attorney can't have an outside legal practice.
Oh, okay, it wasn't, okay, yeah, all right.
I got everybody. Delegate Anderson.
Yeah, I'm always confused with this local courtesy stuff. Are we for local courtesy or are we against it? Apparently,
This
that was
time
a
of session, it becomes harder to tell, but yes.
apparently that was a rhetorical question. But this is not Shoemaker's district, right? He can still keep his practice.
Yeah.
Yeah, Delegate Shoemaker is not allowed to participate in this debate, but he can't, the idea behind the bill is you wouldn't be able to have an outside legal practice if you were the state's attorney in Carroll County. That Carroll County would be joining 21 other jurisdictions that don't allow people to have an outside practice. The only other two that allow people to have an outside practice are Garrett County and the city of Baltimore.
Where you apparently can buy things.
Yeah, let's not go there. Are there other questions for on this bill?
Mr.
Yes.
To the
Chair,
previous question.
I have a
Not-
question.
one-
Oh, I have a
one
que-
more
I have
and
a
then we're
comment to
done.
Kurt. Can I comment? to
Yeah.
Mr. Kurt?
Can you
Well,
what?
Kurt, many years ago, the public defenders were not allowed to have a private practice, and so a lot of them left. This was in Harford County. So this is not a really outlandish bill when it's the head hoo-ha for Carroll County state's attorney that they can't practice. Just saying.
Okay, I'm with you. I just didn't know.
I
if
know,
we're-
but you know, it's this local courtesy thing, you know?
Right.
What can I say?
Yeah,
You're
but-
mad because we didn't vote for one bill.
Not mad, angry.
So you think mad means you're foaming at the mouth? That doesn't mean you're angry. To me,
Yeah.
it means you're angry.
Okay.
Okay, all right, just saying.
There's difference between Harford County and Baltimore City.
Yeah, but I feel that there should be some license here because I've served with you for 20 years now. You should be nice to me. I should be nice to you. But it doesn't mean we have to have local courtesy. That's all.
Wow.
I'm just
Okay.
messing with you, Kurt, because you're fun to give trouble to.
Yeah,
Okay,
I'm
I've
okay.
started to
I'm-
lose the thread of where we're going here, so I'm gonna.
There is no thread.
Okay, thank you. That's what I needed to know. Delegate Cardin?
Mr. Chair, I was just going to take exception to calling the state's attorney the head hoo-ha, but I'll leave it at that.
I could have said
Are
a
there
lot
any
of
further
things.
questions about the bill?
How do I get my hand down?
All right, Delegate Anderson is finding the mute button for at least a moment. But
Oh,
we
shoot,
did
the
a
mute
vote.
button.
Yeah,
Okay.
don't swear on here. All right, that's fine. Doing really well. Just hang in there, guys. Not that much longer. Do you actually have another question, Delegate Anderson, or no? No. All right. You're muted now. Oh, stop. All right, so I will pull this committee over. Don't make me do it. No further questions on Senate Bill 906, the vice chair.
Yes.
Okay, so Delegate Shoemaker is excused. Or, yes, Delegate Anderson,
Yes.
Eric Han,
Nice picture.
Eric Han,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanika Fisher,
Yes, Mr. Chair.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes, sir.
Munoz,
Yes.
Betty,
Yes.
Jam.
What bill are we again? No, just kidding. Yes.
Lord God Almighty. Tolles,
Yes.
Williams.
Do I have a quick question? No, I don't. Yes.
19.
Mr. Chair,
Uh-huh.
could you make Kurt stop making me laugh?
It's been here over 20 years. He can't stop making anybody laugh at him. All right, Senate Bill 950. The problem on my screen is that the picture of me is staring at me, which is really disconcerting. So having said that, Senate Bill 950 is, we've got a letter from the Wacomico County senators, from the delegates, from everybody. This raises the salary and expense allowance for the Orphans Court judges of Dorchester County. Well, actually, no, this is 988. That's the wrong one. Wait a minute. Oh, these are all messed up now.
I move
This
favorable
one.
anyway.
Yeah, I know. We're gonna move favorable anyway. So there's a motion for favorable. Is there a
second
second?
anyway.
Okay, great. Raises the salary from $9,500 to $11,600 to be paid quarterly. That's the annual salary. The annual salary is 11,600. And they get a traveling allowance of $1,560. So they're raising the salary by $2,100. Do you have any questions? Delegate Fisher has a question.
I know I do. It's rare these days. It's more of a holistic question. I'm for the bill, Mr. Chair. I just was wondering, like, is this year just a certain time of year that a lot of these positions needed salary increases? Is that just the commonality that's been going on?
They normally come in the fourth year of the term, because then they can raise the salary for the next
The
term
next
to
cycle.
start. So you're not voting for your own, well, the increase isn't for the person who's there right now. It's for the person who would start in the next year. Okay, thumbs up from Delegate Fisher. All right, are there any other questions? Seeing none, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
That's 20. Second verse, same as the first, Senate Bill 988. Now we're in Dorchester County, where they're raising the salary for an orphans court judge from $4,700 to $6,000 annually, and their expense allowance goes up from $800 to $1,000. Can I have a
Move
motion
favorable.
Second.
and a second? Any
I'm sorry, what's the
discussion?
bill number?
This is 988, cross-filed with 1456, which we're going to see in just a moment. Delegate Bartlett. You're muted, though.
Sorry, Mr. Chair, I don't have the bill up. Did you just say,
980
did you say-
988.
did you say raise it from $700?
Raises it from $4,700 to $6,000 for the orphans court judge of Dorchester County.
Thank you.
They get an extra $200 for an expense allowance.
Yep, that makes sense. Okay, thank you.
Okay. Any further? No. Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Fisher, Juanita Fisher, who needs a new mouse desperately. Juanita Fisher, who is still muted and desperately needs a new mouse.
Oh, I'm sorry. Were you on me, Mr. Chair?
Yes.
Oh, my bad. Yes.
Okay. Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Betty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
All right, that's 20. All right, another piece of paper. 1456 is the House cross-file of the bill we just passed that raises the orphans court salary dramatically in Dorchester County by almost 20%. Are there any 25%? Are there any questions? Could I have a motion?
Move
Move
favorable.
favorable.
There's a second.
Second.
Great. Any questions? Seeing none, the Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas. McComas? You lose her?
Yes,
Oh, there
yes.
you are. Munoz,
Yes.
Shetty,
Yes.
Jam,
Yes.
Bowles,
Yes.
Williams.
Yes.
20. Gonna skip over Senate Bill 68 and get to now, I don't believe this bill was cross-file, was not. Senate Bill 38. Senate Bill 38,
Move favorable.
motion for a favorable. Is there a
Second.
second? All right. What this bill does, it requires certain state or local fire or and rescue entities to reimburse individuals who take possession of dogs formerly used in fire and rescue work under a written agreement for veterinary treatment. That's what the bill does. Delegate Fisher has a question, though.
My question is, can you explain the money part of it? I'm trying to read it really quickly, Mr. Chair. So,
Which is this? This is Lauren.
Yes, the amount is up to $2,500 for reasonable and necessary veterinary treatment. So when the dog is retired and it's a fire and rescue work dog, and the handler decides to take possession of the dog at retirement, that handler can be reimbursed up to $2,500 for veterinary care.
and who's reimbursing them?
It's the state or local fire and rescue entity that is removing the dog from service, and they can accept donations to meet the bill's requirements and establish a special fund under the bill.
Yeah, so right now it's just the police officer who has their canine who can get reimbursed. Looks like 2,500 a year and no more than 10,000 over the life of the dog. This would extend that to the local fire and rescue entities. Delegate Tolles.
I would just want to say, thank you, Mr. Chair. According to the testimony, it looks like the Maryland State Firefighters Association supports it. And the Maryland State Firefighters, so the state, and it looks like a couple other. I just lost my screen off the floor system, but it looks like it has considerable amount of support from those who would be investing and making sure that the parameter of this bill happens. So,
all right.
If you have not already taken a motion, I will move favorable.
I think we did, but okay.
Sorry.
Does anybody want to do second anyway?
I'll second.
All right, great.
Thank you. Yeah, it looks like a lot of animal support as well as professional firefighters and this fire chief. So just wanted to make in case no one saw that on the floor system. So thank you.
All right. Senator Kramer, think about the puppies. That's what. Delegate Crutchfield, Senator. I said it so that she didn't have to. Are there any questions, further questions? Seeing none, the Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes.
Hardin.
Yes.
Cox.
Yes.
Crutchfield.
Yes.
Davis. You're muted still. She's trying.
Yes.
All right. Juanita Fisher.
Yes.
Grammer.
Yes.
Howell.
Yes.
Rachel Jones.
Yes.
Lopez.
Yes.
McComas.
Yes.
Munoz.
Yes.
Shetty.
Yes.
Cham.
Yes.
Tolles.
Yes.
Williams.
Yes.
20. Okay. Senator West has a bill, was not cross-filed. But the Estates and Trust Bar supports it. And it has to do with payment of commissions without court approval.
Move
Um,
favorable.
Motion for favorable. Is there a second?
Second.
All right. Are there any questions regarding Senate Bill 468? Bill clarifies that the personal representative may pay commissions to personal representatives and attorney fees without court approval under specified circumstances. Okay. Seeing no questions, we'll go ahead. The vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez. Lopez? Uh-oh, she stepped away. McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
yes,
Bowles,
Yes.
Williams.
Yes.
Leslie Lopez on Senate Bill 468.
Yes.
Okay, 20. All right, 4 departmentals. Senate Bill 172. I think they're closing this facility, if I'm not mistaken. Is that right? Right, so it repeals obsolete references, including to the Carter Center, which no longer exists.
Move
Can I have
for
a motion,
favorable.
please, motion for favorable. Is there a second?
Second.
Second.
Great. Any questions? Seeing none, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Monica Fisher.
Yes.
I think she said yes. Grammer.
Yes.
Yes.
All right. Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
McComas,
Yes. Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Bowles,
Yes.
Williams. Williams?
Yes. Yes.
Well, that's 20. All right, Senate Bill 203. Senate Bill 203 is where we are now. Can I have a motion?
Move favorable.
All right, is there a
Second.
second? All right. Could we get a quick overview, Lauren, as to what the bill does, please?
Sure. This is adding additional requirements for hearings to review the permanency plan of a child in need of assistance who is in and out of home placement in order to bring the state into compliance with federal law.
All right. Any further discussion or questions about this? Seeing none, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Hardin.
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Comas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
yes,
Tolles,
Yes.
Williams.
Yes.
20. Going to Senate Bill 214 now. Can I have a motion, please?
Move favorable.
There's a second.
Second.
All right. Does anyone, okay, so Lauren, would you tell us what this departmental bill does?
Yes, this one is expanding the circumstances under which child abuse and neglect records may be disclosed. Specifically, it's authorizing the disclosure of reports and records concerning suspected child neglect committed by certain school employees or independent contractors to certain school personnel for the purpose of carrying out appropriate administrative sanctions. And it's authorizing the disclosure of child abuse and neglect records to the director of a licensed child placement agency following a report of suspected child abuse or neglect alleged to have been committed by a household member, a family member, or any person who has responsibility for supervision of a child in a home that is approved by that agency for the placement of children.
I remember that there was a lot of back and forth on this legislation. So, I'm happy. Let's have some discussion here. We've been dealing with a lot of bills that were relatively straightforward. I don't know that this one is. Senate Bill 214. Go ahead, Delegate Erican.
Thank you, Mr. Chair. So I'm still very concerned with the premise of this bill. I mean, it's one thing if there's been, sorry, my phone's ringing. If there's been an actual conviction of someone, but these are just allegations. And what we're going to be doing is setting up a system where the government is going to be telling someone, for example, let's say you had a child that went to a daycare, someone has alleged something against you. There have been no facts sustained. We do not know if the allegations are accurate or not, but now they're going to go to your daycare facility to tell the people that run your daycare facility that you're like a suspected child abuser. I feel like it's going to color the window with which the employees are looking at these parents and prejudice them against these parents without quality evidence. I just don't know if you could put lipstick on this pig. It's bad. This is a bad bill. And I would really caution us against prejudicing people's daycare providers against them when they haven't actually been convicted of anything. I think it's harmful, not just to the children, but especially to the parents who, deserve to have their day in court and to have the facts looked at and not have people in their personal lives sort of turned against them to spy on them when there's been no finding of guilt. That makes me very uncomfortable. And so that's what I'll say about this bill.
Delegate Cox.
Thank you, Mr. Chair. You might recall, committee, that during the hearing, I asked the question, I think Delegate Erican may have and others, whether or not this needed to be a finding of indicated abuse or unsubstantiated abuse, which by law would have to go into the state database before it can be shared. And the answer to that was a loud and clear no. Literally unfounded, illegal, and false complaints, which are generally ruled out, would still have to be shared, which that to me is a little surprising because the law says they have to be immediately expunged. But this is a workaround that system so that you don't necessarily have to expunge it. It can sit in the file and then be released upon request of this process. That's my reading of it. That was my direct question to the individuals there, and she confirmed it. And in the reach out, she did send me something. I forget her name, but working for the department, sent me a document trying to alleviate some of the concerns, but it does not alleviate my concern. And I would just close with this thought. The most hard hit communities will be the most underprivileged. They're the ones that have very little representation. I know this for a fact because of my work in my other hat. So just to let you know, this is, I think, a very unfortunate step in the wrong direction for the state of Maryland. I would not, I won't be supporting it for that reason.
Delegate McComas.
Thank you, Mr. Chair. I want to ask Delegate Cox, was it Lauren Graziano that called you?
I'd have to check with my staff.
Okay. Well, anyway, let me just ask, give you some thoughts on this. I was here a long time ago when Tony O'Donnell wanted to have a hearing on Sierra Jobs. And this was I believe this was the little girl that was given to a relative who was actually schizophrenic, and the woman got custody of the child. The child was starved to death, and she was put in a room where she was going to the bathroom in a hole in the wall. And it was tragic. It was awful. So he wanted to have a hearing on what happened to this little kid. In other words, why did this happen? Because that the person, the schizophrenic caregiver, should not have ever had custody of this child. And she wasn't going to school, and there was all kinds of issues. Anyway, long and the short is, oh, we can't tell you anything. Nothing. And I don't know the rest of the story at all. I just know that it was during session. He wanted to have a hearing in front of the Judiciary Committee, and it was crickets because everything had to be confidential. Well, I think that some of these issues are very broken. And my thought is if we don't want to pass the bill, I think we should turn it into a good task force and try to draw on, because it seems to me the system is still stovepiped. And the system doesn't have the capacity to investigate everything that we want investigated or looked into. And I can understand, I can sympathize with the concerns that my colleagues have, but I also think that we're dealing with children that if they're falling through the cracks and they're dying, or they're being abused, or they're being neglected. So we've got to figure out something that works for both sides involved in this, the family as well as the child that needs some help. So I would say, if we can't get this, turn it into a task force and try to see if we can make some improvements on the child welfare system for the kids, because they're the ones that really can't take care of themselves and reach out and say, hey, there's a problem, or articulate it. So that's my thought.
Delegate Cardin.
I'm on mute. Thank you. I'm just asking, so is the purpose of this is to expand for allegations of neglect, or to expand the ability for the administration to be able to inform childcare and other entities? What's the purpose of the bill? We didn't get any testimony. I just happened to read through, while we're doing this, read through the testimony. We didn't get any testimony from any of the advocates. This is strictly departmental.
Yeah.
And the AG's office did chime in.
It looks like it's seeking to extend the information that could be made available from previously child abuse involving a student. It strikes the involving the student. So now it's any child abuse or neglect committed by a public school employee, an employee of that non-public school, an independent contractor who supervises or works directly with students in that school system or that non-public school, or an employee of an independent contractor, including a bus driver or bus assistant who supervises or works directly with students in that school system or that non-public school. So it appears to, and I believe it would certainly extend the number of people for whom information could be disclosed. At least that appears to be the intent of the bill. And let me just flag here, I think it would be my intention, since there appears to be some concern that I'm picking up, that we may hold on to this one and maybe come back. So let me just signal that right now, if that impacts other people's interests.
Yeah, I mean, maybe we should reach out to like the youth advocacy groups and just kind of make sure.
That would be my inclination. And why don't we, Delegate Grammer, I'm kind of inclined to hold it unless you have a further question you'd want to address, but it's up to you.
I do have a question just from my own understanding. So this seems like the majority of the bill is regarding child placement agencies and making sure children aren't placed in homes where they're abused. Can somebody help me understand what licensed child placement agency is?
Lauren?
I will grab that definition in just a minute. I just want to, I think it's in the family law part of the, and this is in human services. So just 1 second, please.
Okay. And I hate to belabor this, but I'd really like to just understand more clearly what that is.
That's fine. Why don't we do this? And since I'm going to hold it anyway, we'll get that information and I'm going to move on here so that we can keep going. But we'll get that information to you and I won't have Lauren totally running around just yet. So we'll hold on to that one and we'll come back. We are going to go now to Senate Bill 216, another administration bill, this one regarding breath tests. Regarding breath tests, it transfers specified approval and oversight authority regarding breath alcohol and blood alcohol and drug tests in the investigation of specified motor vehicle and vessel offenses from the state toxicologists in the chief medical examiner's office to the toxicologist at the Department of State Police to their forensic science division, makes other conforming changes. Is there a motion?
Move favorable.
Is there a second? Second?
Second.
All right.
Second.
All right. Are there questions regarding this legislation? Cardin and Grammer appear to have their hands up from before. Unless they don't. All right. Are there further questions? Seeing none. Are there any questions? The Vice Chair?
Yes.
Shoemaker?
Yes.
Anderson?
Yes.
Erican?
Yes.
Bartlett?
Yes.
Cardin?
Yes.
Conaway is excused. Cox?
Yes.
Crutchfield?
Oh, yes.
Davis?
Yes.
Fisher?
Yes.
Grammer?
Yes.
Howell?
Yes.
Rachel Jones?
Yes.
Lopez?
Yes.
McComas?
Yes.
Munoz?
Yes.
Betty?
Yes.
Cham?
Yes.
Tolles?
Yes.
Williams for
Yes.
20. Okay. Committee, we're on Senate Bill 68. Senate Bill 68, I'll be clear, deals with an issue that has been very difficult for this committee in the past and will continue, I think, to be difficult. It is a very, we've had a difficult time with the bill in the past. And it's not necessarily because of the bill, it's because more of the subject matter. So I will leave that there. I have indicated to the subcommittee chairs, and I'll indicate now that I certainly will entertain a hold at the end of the discussion here today, and we'll hold this until the next voting session. But I wanted to at least bring out the bill and get a sense for what people thought and people's thoughts related to the bill. So with that, we'll go to discussion. I know there's no motion. We'll deal with the motion in the future, but we'll go to discussion, and Delegate Crutchfield, please.
Thank you, Mr. Chair. I just wanted to bring to everyone's attention that there is a racial equity impact note on this bill, and that we should all probably take a look at that as we review this.
Delegate Juanita Fisher.
I was going to say the same thing, and I did review that note, actually, Delegate Crutchfield, and it wasn't really that helpful to me in figuring out the racial impact on victims and defendants. And I think and unless there are any advocates that have emailed Mr. Chair, my same question is still unanswered for 2 years, which is when people petition to get off of the registry, how many people are successful getting off? And I think, my concern with this bill, like so many others, is I believe, when you do something wrong, you should be held accountable in our court system, but a lifetime registry is forever. And I think at some point, punishment has to end, and then you have rehabilitation, unless you think it's a lifetime crime. So, those are still my concerns, and that's still information I'm constantly wanting to know about, and more just demographic input on it. But those are my comments, and I still have my same concerns, Mr. Chair.
Okay. All right. Are there further questions or discussion about the bill? Delegate Davis, it was my understanding that you were interested in potentially holding the bill for a day, but if you're not, that's fine too. I'm going to do it anyway. But that's fine. You're muted. You're muted right now. If you have a question, go ahead.
I'd like to hold the bill until April 13th, but Mr. Chair, this bill brings strong emotions for so many different reasons, and I don't think we've resolved them. The idea, it's a philosophical difference. It's, tough on crime, just throw people away, or it's, we can try to get people help. And this bill tries to do them both, I think, by requiring people to have absolutely to go to sexual offense training, whatever the word is, counseling for a lifetime, and pretty much incarcerates them in their own houses for a lifetime. And I think we have a philosophical difference about it. And it's going to be a really tough one. It's going to be a really tough one. We've got several questions that haven't been answered. I don't think we're ready for prime time.
Delegate Arakan.
Could council just explain to me? I thought this was just about parole. I didn't. So that this is not changing the maximum jailable penalty, right? This is just about this is like not even parole. It's about, I thought it was about supervision, not even parole. So I'm not sure what kind of like forever in jail thing we're doing, but could council just tell me exactly what it does?
Claire, please.
The bill does several things. It expands the definition of crime of violence.
Thank you.
Includes sexual abuse of a minor when the offender was at least 21 and the victim was younger than 16 at the time of the offense. And then the bill also expands the list of persons subject to lifetime sexual offender supervision to include a person who's been convicted of sex offense in the second degree or an attempt to commit a sexual offense in the second degree. If the victim is a certain age, and also to include a person who has been convicted of sexual abuse of a minor involving a child of a certain age.
Okay, so it doesn't expand the time frame someone could be in prison. It doesn't.
That's correct.
It doesn't put a new class of people on the sex offender registry. It doesn't do any of those things. It just expands potential for lifetime supervision, which really just means it doesn't require lifetime supervision, does it?
Well, it requires lifetime supervision for additional people, but okay. It's called lifetime supervision, but a person can petition to get off of it. So it's not always for a person's lifetime.
Okay, so that helps like show us what this bill is really doing, because the comments before confused me and made me think we were on a different bill. So this is just about lifetime supervision, and maybe the chair knows better, but lifetime supervision is not like lifetime ankle monitoring or something like that. This is just check-ins with a parole officer or a judge. Is that correct? At a time, as I assume, established by the judge when they sentence.
Well, it's, it would depend. It's on a case. The term conditions of the supervision are on a case-by-case basis and depend on the particular defendant. But for each defendant, they get this committee of, professionals who would, monitor their case and review their case and monitor the progress of the person. And so there would be different, conditions for each person.
So perhaps we should change the term from lifetime supervision to lifetime help, because that's what this really does. It helps them stop raping children. It's attempting to help people stop raping children instead of allowing them to recidivate and go back into the system repeatedly for the same crimes. This gives them access to resources and someone to make sure that they're not raping children anymore and keep an eye on that. So thank you.
Let me ask a question of Claire as we go on. I'm on page 4 of the bill in line 25 and 26. My impression for that part of the bill is it's merely clarifying that what was sexual offense in the second degree, it strikes 3306 A1 or A2 and just clarifies that should be sexual offense in the second degree entirely as it existed prior to October 1st, 2017. Is that correct?
Yes.
Yeah, okay. So part of the reason I think for the bill, at least in that part of the bill, was was basically a technical change that it was seeking to. And I mean, am I right, Claire, in saying that it was a technical change, or am I misreading that?
I think it is a technical change, but it matters to prosecutors.
All right. Okay. Let's go to Delegate Munoz, then Cardin, then Grammer, then McComas. Delegate Munoz.
Thank you, Mr. Chair. I just wanted to share with people who may have concerns about this bill. I'm trying to remember, I don't think it was in law school, but I believe when I studied counseling at the graduate level, I think we learned there that people who commit sexual crimes against children have a very high repeat. Yeah, they're very high repeat offenders. And it's a huge issue when treating those individuals. And so I would just wanted to suggest people who have issues with this bill and with, continually monitoring people and providing assistance, like the other delegate said, to people who have committed sexual crimes against children. I would suggest maybe look into some of that data and see how you feel about, the prospect of these people committing sexual crimes against children over and over and over and over, different children, different crimes, different victims, or, them having some more assistance, some more help throughout their lifetime to make sure that they don't commit these crimes anymore. I don't think, from my own perspective as a mother, I don't think that, monitoring people who have committed these types of crimes to make sure they don't continue to commit them is a bad thing. I think it's a good thing, not just for the victims, but also for these individuals who have this propensity and this issue. So I don't have obviously the numbers in front of me, but I do remember that sticks out to me. So people might want to just go look into the data and see, how that kind of makes you feel. Thanks.
Delegate Cardin.
Thank you, Mr. Chair. Just 4 questions or 4 comments. One is that I think this does actually, just in response to Delegate Arakan, this does expand the number of people that are going to be on lifetime supervision. I think that was pretty clear the way that it was explained by Claire. I think that we should get a response on Delegate Fisher's question, which is, of the people who have tried to petition off, how many were able to petition off? Because if we find out that 75% are able to petition off after they've shown a change in their behavior and positive reports from their supervisors, that's different than if 0% were able to petition off, regardless of what their supervisors had written about them. And then, are you able to freely be able to move around, to move states, to be able to have have the freedoms that if you have served your time, your criminal time, are you able to then enjoy the freedoms of a citizen or not? That's another question. And when applying for jobs, if you've served your time, you've done everything, and you have been very honest, but you're on this lifetime supervision, which is not meant to be a penalty. It's meant, as has already been indicated by some of my colleagues across the aisle, it's not a penalty. It's something to help make you a better person. If that is hindering your ability to change jobs or get jobs, is that something that we should take into context when we're thinking about voting on this bill? So those are some of the comments that I have.
Delegate Grammer, then McComas, then Fisher.
Thank you, Mr. Chair. So I wanted to respond to Delegate Davis's concerns as someone who's not single-minded on these types of issues. And if you read pages 4 and 5, where that's the whole meat of the bill, is adding this new category under the supervision, and you read what it applies to, the person who's been convicted of a violation of under 3602. It's essentially, and if you remember back to the bill hearing, they talked about this. This already applies to children under a certain age. And what you have is this kind of, I don't know if it's a loophole or it's this weird age bracket where, if it involves a child under 12, it can be prosecuted, but if it's a child under 4, if a 14-year-old, suddenly, the penalty's much less. And what it's essentially saying by adding, page 5, line 7, is that if an older person does this to a child under the bill between 13 and 16, this would also apply in that case. So it's not necessarily expanding this radically. All the bill does in this particular case is saying for if you're 13, 14, or 15, and you're charged with this and you're over 21, this also applies to you. So if you read it, the bill in the totality of it, it's not necessarily expanding this code greatly. It's just applying this to this weird age bracket. And it's not really fair to say, okay, well, if the victim is 12, we're going to provide lifetime supervision, but if they're 14, well, sorry. So I think this is closing a little bit of a loophole and expanding some protections. Frankly, I think a 17-year-old, I wouldn't treat a 12-year-old similarly at all. And I would just urge the committee to read pages 4 and 5, and it's not that great of an expansion. So this is a pretty easy one to support for me, and I think it would provide some protection for adolescents in our state. Thank you, Mr. Chair.
Delegates McComas, then Fisher, then Davis, and then we're going to hold the bill. Delegate McComas.
I think it would be really good if the whole committee could read the letter of support for this bill by Jamie K. Sterling, Assistant State's Attorney for Anne Arundel County. I happened upon this one, but let me just read this. Studies have found that approximately 1 in 5 girls and 1 in 20 boys are victims of child sexual abuse, with children between the ages of 7 and 13 being the most vulnerable. And she's cited her sources. Additionally, 3 out of 4 children were victimized by someone they knew well. Also, she cited her reference. This legislation aims to fix a dangerous loophole, which coordinates with what Delegate Rammer said, and protect our most vulnerable victims. So I think what we need to really think about is, and we've seen this with testimony regarding child abuse, at least like when there's been ideas to expand the statute of limitations for sexual offenses, how devastating it is to the folks that have been victimized. through their adult life. And it's left a lot of heartbreak and scars. And we have a member in our legislature that it's been a rough road. So I guess what I'm saying is I think we have to do what we can do to protect people. And I think that there's really no cure to this stuff, because Dr. Berlin had the sexual offenders clinic at Hopkins. I don't know if he's retired now, but he was considered an expert. People would come that had these problems around the country. He would testify for defendants and everything. There was Depo-Provera, all kinds of things, but I don't think there's a fix for this, and or a magic pill that you can take. And I think it's something that literally these folks have a tiger on their back, and you can't get rid of it, and it causes to the victim. They have alcohol and drug addictions because of the abuse that they have suffered. And one of our judges up in Harford County, he's retired, but he always used to say, if there's drugs or alcohol problem, you scratch deep enough and there's been sexual abuse. And he used to be a master, and then he was a circuit court judge, and then the chief judge for many, many years. And I think he's right on it. It's Judge Carr for Kurt, so he knows who it was. So I think that this is a serious problem. And I know that some of us have a little bit more leaning toward the defense, and we feel that that the system might be skewed, but look at the victims. The victims are, they're living a hell every day. So that's what I'm just saying. It's a good bill.
Delegate Fisher, then Delegate Davis, and then I'm going to say that we're going to stop.
Thank you, Mr. Chair. First, I want to ditto the comments made by Delegate Cardin. He was very eloquent on my concerns. I had a question for Claire. Right now, without this bill, no law change, can a judge in the circuit court put someone on lifetime supervision in these cases if they feel so opportune to do?
I don't think it's discretionary. I think the statute sets out what, kind of convictions subject a person to the lifetime sexual offender supervision.
Right, but in the bill, it's changing. I'm sorry, I have too many tabs open. In the bill with the age change, and let's say it didn't change and you had someone, okay, it's changing it. It says involving a child, it's going from 12 to 13, or was committed when the person was at least 21 years old and a child was under the age of 16. So right now, today, on April 7th in Maryland, if someone's 21 and the child is 15, what does a judge have the capability of doing?
Okay, well, that part of the bill that you were just referring to is the first part of the bill that doesn't directly relate to the lifetime sexual offender supervision.
So what does? I guess my question is just all my unanswered questions. I think it'd be helpful to know what is capable of right now, and then what this bill with the changes or this legislation would then bring. And then my other comments that I wanted to, just for the record, Mr. Chair, when you look at it's 11-724 F5 number 2:2, it lines out the hearing requirements to get off of lifetime, which is pretty extensive on those hearings. And so maybe the question that I brought up about, how many folks have had those hearings and what the results would be for the judiciary to bring us that information.
Where are you looking? I'm sorry.
11-724 F5(2) in
existing law.
Yeah, in the existing law. It just goes through like the what's in statute for the hearings on the registry.
Right.
And I guess I was just bringing that up, Mr. Chair, and that it maybe be a judiciary question on from those hearings, what are the percentages of those results?
Oh, I see. Okay.
You know what I mean?
You're not talking about how anything was excluded from the bill. I misunderstood you. You going back to your previous question about how many people petitioned to get off of the lifetime registry, can we find out how many people were taken off the lifetime registry.
Yeah, and so maybe I've been directing my question in the wrong avenue. Maybe my question's better directed
Right.
with the judiciary, since there is you have to have that hearing request and
Well-
go through those statutes, and I think that would be really helpful. So I will just leave it there.
To your first question, I believe that, it's the guidelines for when a judge can do a lifetime supervision. I think that's what's defined in the law under 11.723. But let's get an answer to that other question that you have. So if there's a 21-year-old and they sexually abuse a 15-year-old, what can the judge do now? I will make sure we have a direct answer to that. With respect to Delegate Munoz, I'm going to let Delegate Davis stop us right here, and then we'll hold the bill until at least tomorrow. Delegate Davis.
Thank you, Mr. Chair. Delegate Fisher just brought up another issue that I'd like to question on. What about if someone was mentally impaired? If the alleged perpetrator was mentally impaired and 21, how does that work? Or if that makes a difference at all. But in my own defense, since I have a singular view, I just want to make it clear to the committee that I have been meeting with the sponsor of the bill. And I'm surprised to see it in this condition still, because we had thought of some other ways to make it more palatable to probably to this committee or to some people on this committee. But anyway, thank you.
That's fine. As to the question as to, if somebody were deemed to be, I guess the question would be if they were not criminally responsible. Your question isn't about not criminally responsible. It's about, so give me your question again, Delegate Davis.
Maybe diminished capacity as a 18-year-old or 21-year-old.
But okay, so
that wouldn't be not criminally responsible.
So they had a diminished mental capacity, but they were still found to be criminally responsible.
Mm-hmm.
Okay. All right. I'm going to stop us right here. We are done with the voting session today. We will have another voting session tomorrow, and we will deal with several other pieces of legislation. But for now, and I again recognize Delegate Munoz had more to say. We'll come back and I'll make sure that we hear from you again when we come back to the bill. But I'll hold it for now. Tomorrow we have 2 sessions. We will be voting at least in between sessions. We may vote after the second session. There will be a Saturday session. So I'm just putting everybody on notice that there's a significant chance that we will vote at least in between, 50-50 chance of after the second session. So there's that. With that, this has been the House Judiciary Committee on the 7th of April, and we thank you all very much. Bye-bye.